I call this meeting to order. Good afternoon and welcome to this joint meeting of Senate Finance, Appropriations, Public Safety, and General Government Subcommittees. As many of you are aware, in addition to the various important budget pressures facing our subcommittees, potential legislation to legalize marijuana will be a pressing policy issue in the 2021 session. JLARC has recently reported on considerations for marijuana legalization, including estimated fiscal impact for regulation and other aspects of legalization. To that end, we have invited JLARC to present an abbreviated version of its November report with a focus on fiscal impacts and related criminal justice issues. Following JLARC, we will hear from Colonel Settle with the state police to discuss the agency's budget pressures and a general overview of the existing records expungements process. Representatives from the Supreme Court will follow with an overview of the court's existing expungement processes and update on system improvements. Senator Peterson, before I turn it over to you, I just want to remind you that we have a full agenda today. We welcome members to ask questions, but please keep in mind that JLARC's information has been cut down from its original report, as we have asked staff to focus on the fiscal issues of interest to the Finance and Appropriations Committee. Now, before I turn it over to Senator Peterson, I'd like staff to please call the roll.
All right. Senator Lucas.
Here.
Senator Normand. Senator Ruff.
Here.
Senator Edwards. Senator Peterson.
Here.
Senator Marsden.
Here.
Senator Eben.
Here.
Senator
I'm
Newman.
here. John Edwards, I'm here.
I got you, sir. Thank you.
Yep, you got you.
Senator Newman.
Here.
Thank you. Senator Vogel. Senator Locke.
Here.
Thank you. All right, Madam Chair, Mr. Chairman, that completes the roll.
Thank you so much. Now we'll turn it over to Senator Peterson to make introductory comments. Senator Peterson.
Thank you, Senator Lucas. I'm going to break away from longtime tradition and actually read off the script this afternoon. Good afternoon. I'd like to echo the comments of Senator Lucas and thank you all for being here for the special joint meeting of the Public Safety and General Government Subcommittees. As indicated today, we'll hear from JLARC to discuss their November 2020 report entitled Key Considerations for Marijuana Legalization, focusing specifically on some of the key cost drivers and recommendations. The subject of marijuana legalization is one that's obviously complex and will require a deliberative and thorough examination. Given that, we've invited JLARC to discuss their report in advance of any specific legislative proposals, so our members will be well versed in the subject as we consider its potential costs and benefits to the Commonwealth. In addition, we'll have representatives from the Virginia State Police as well as the courts to talk about the existing petition-based expungement process and any changes that may be required as a result of either marijuana-related or other legislation. The governor has included $25 million over the biennium in his introduced budget to cover costs associated with expungements, including not limited to automatic expungement of marijuana-related misdemeanor convictions. So we'll get details on that. Mechanically, please mute your line when you are not speaking. And if you step away or are engaged in some other business, please turn off your video. And that's really all I'm going to have. I'm not going to make any editorial comments, but just will listen. And with that, Senator Lucas and I would like to invite our first presenter, Mark Gribben with JLARC, to speak.
Thank you, Mr. Chairman, Madam Chairman. I'll just pull up my presentation. Good afternoon, Madam Chair, Mr. Chairman, members of the committee. I'm Mark Gribben. I'm with the JLARC staff, and I'll be giving you a summary of our report on marijuana legalization. I'll start off with a little background. Our study was directed by legislation passed in the 2020 General Assembly. I'll emphasize we were directed to look at how Virginia could legalize marijuana and create a commercial market. We were not asked if marijuana should be legalized, and we did not weigh in on that question. Our report uses the term marijuana because this is the common term for the intoxicating flower or products derived from the cannabis plant. It also distinguishes it from hemp. Marijuana is, of course, a federally illegal substance, but has been legalized for adult use by 15 states and Washington, D.C. Virginia has not legalized marijuana for adult use, but marijuana possession was decriminalized in the 2020 session, and the state also established a legal medical marijuana market, which began sales last year. When we talk about the legalization of marijuana for adult use, we're really talking about two main parts. The first part is changing the state's criminal laws to allow adults to legally use and possess marijuana without penalty. The second is establishing a commercial market where marijuana can be legally produced and sold. I'll cover changing laws to legalize adult use first. Prior to decriminalization, state and local law enforcement made 20,000 to 30,000 arrests per year for marijuana offenses. Most of those, about 90%, were for possession of small amounts of marijuana. While a lot of individuals have been arrested for marijuana in recent years, many of those cases did not lead to a conviction, and most people who were convicted were only fined or charged court costs. Around 7% of marijuana charges did result in a jail sentence, but those were mostly cases where there was a distribution charge or additional offenses like another drug or a weapons charge. Few individuals were incarcerated solely for marijuana possession. The other key point I'd like to make here is that marijuana arrests and convictions have been disproportionate by race. Black Virginians were arrested 3.5 times more than white Virginians for possession, and convicted 3.9 times more despite using marijuana at similar rates. So what would happen to arrests and convictions after legalization? We took Virginia's historical arrest and conviction numbers, and those are the overall numbers for everybody, and projected what might happen under decriminalization and then under legalization. We found that these two actions could reduce arrests and by extension convictions by around 84%. Decriminalization, which of course has already been enacted, has the bigger effect because it eliminates most possession arrests. Legalization would further reduce arrests, especially for more serious marijuana offenses, but not by as much. Despite the reduction in arrests and convictions, we found legalization would have a surprisingly limited impact on the criminal justice system. When it comes to law enforcement, legalization appears unlikely to lower costs because marijuana arrests only account for around 0.1% of officers' time. Looking at it another way, service calls where marijuana is actually found and seized accounted for only about 0.6% of service calls. Looking at the courts, we found that legalization would likely only have a minor impact on court workloads. While there have been thousands of marijuana court filings each year, they made up a small percentage of overall filings and didn't take up much of a clerk or judge's time. Additionally, possession has been decriminalized and most penalties are now prepayable, which means the marijuana-related workload under current law is likely lower than it used to be. Although legalization would have minimal cost impacts, it could also actually reduce the revenue that the state collects through courts by $1 to $2.5 million. And of course, that revenue flows through to the general fund and a few other funds. It does not go to the courts themselves. Finally, looking at state and local corrections, legalization might reduce costs by about $1.5 million. But that money would be spread out across all state and local prisons, jails, and probation programs. When legalizing marijuana, there are a number of changes the state would need to make to the criminal code and punishments for violations. This slide bullets out the main areas to be addressed. We have a lot more detail on this in our report. Like decriminalization, the changes to the criminal code could be quickly enacted and put into place. For example, decriminalization was passed in the 2020 session and went into effect in July this past year, and the same could happen with the changes to the criminal laws for legalization. One option that the General Assembly could consider as part of legalization is expunging records for marijuana offenses like possession. A one-time expungement of marijuana possession offenses could benefit around 120,000 Virginians, including 63,000 Black Virginians. JLARC staff looked at options for doing a one-time expungement of past marijuana offenses only. So this was different from the broader expungement efforts that were proposed in the recent special session. We found that a quote-unquote automatic expungement process would benefit more people and be more equitable than a petition process. Petition-based processes tend to have lower uptake rates because they are not always easy to navigate, and so tend to benefit people with more time and resources. In an automatic process, the state would identify the records to be expunged, and state agencies and local court clerks would proceed with expungement. While this would remove the burden of petitioning from the individuals, it would be a very labor-intensive process for agencies and especially the courts, and there could be significant one-time costs associated with that. This slide sums up our key recommendations and options for changing the criminal code to legalize adult marijuana use. In the interest of time, I'll skip over these, but I will also pause in case there are any questions. I'll defer to you, Madam Chairman, and you, Mr. Chairman, as to how to proceed. Looks like I should just keep going.
Keep on
Yes,
going.
please. Yes, keep going.
For the rest of the presentation, I'll be diving into the second part of legalization, which is establishing a commercial market. I'll start with how the state could structure and regulate that market. A commercial market provides a place for marijuana to be legally bought and sold. If you legalize marijuana but don't establish a market, there is no legal place to buy it, and you're essentially ceding marijuana sales to illegal operators. However, marijuana is federally illegal, so your commercial approach has to be acceptable to the feds. So far, they have indicated they will not interfere in state markets as long as those markets are tightly regulated and prevent criminal activity, restrict youth access, and protect public health. Looking at commercial marijuana markets, there are 5 major operations. Cultivators grow and harvest plants, often indoors, but also outside or in greenhouses. Processors convert raw plants into products like vape oils and edibles. Distributors wholesale, store, package, and transport marijuana. And retailers sell marijuana to consumers through single-purpose stores, sort of like liquor stores, or through home delivery services. And finally, testing labs test products for safety and quality. In theory, the commercial market could be fully private, or the government could play a role. The government model would look a lot like the state's liquor market under ABC, with a state agency controlling distribution and possibly retail. In a fully private model, all operations would be performed by licensed private businesses. Businesses could be vertically integrated, which means they could hold all license types except testing, or the state could decide to break up the supply chain and prohibit cultivators and processors from also owning retail licenses. Under either approach, it's important that the testing labs are independent to ensure their objectivity. This slide lays out the key differences between the different models. You can see that the government model has some appeal, but is probably not practical due to the risks of federal intervention, lawsuits from other states, and the time and money needed to set it up. While the 2 private models are not without their own risks, they have been successfully implemented elsewhere. Each of these leans towards a particular set of priorities. Allowing vertical integration, like Colorado, would lean Virginia towards having a more robust market that could better reduce the illegal market and generate more tax revenue. Alternatively, Virginia could prohibit vertical integration, like Washington State. This would probably make the market a little more friendly towards small business, and by extension, could provide more opportunities for social equity business ownership. It could also promote slightly better health outcomes because presumably prices would be a little higher, and so people would buy a little less. I would caution, however, that none of these outcomes are guaranteed, and it would be possible to achieve any of these outcomes under either of those approaches. After determining the overall market structure, the state would need to settle on the basic rules for the 5 different license types. The main takeaway here is that the rules for each license type can and should be a little different, and we have a lot more discussion of how that could work in our report. The state would also need to determine what powers and authorities local governments should have. The biggest decision here is whether or not they should be allowed to prohibit commercial marijuana activity. As you can see on this map, we found that southwestern localities are probably more likely to prohibit commercial marijuana. However, because these areas are less populated, allowing local prohibitions probably wouldn't weaken the state's overall market. Additionally, even within these regions, we expect a few localities would allow marijuana sales, so there would probably still be legal access throughout the state. Another big question is what to do with the existing medical market and license holders. We found that current medical license holders could be allowed to participate in the adult use market. However, we would strongly recommend against granting them early entry. Some other states, like Illinois, allowed their medical folks early entry, and they were able to start sales in just a few months and generate some early tax revenues. However, Virginia's medical market is not near as large or developed as Illinois was at the time, or it's also smaller and less developed than all the other states that have taken this early approach with their medical licensees. Virginia would likely experience severe and prolonged shortages of both adult and medical use products if it took this approach. Looking at the long term, we found that eventually the medical and commercial markets should be merged, probably around 5 years down the line. There aren't big differences in what these license holders do, so combining them under one regulator and set of regulations would be better and easier for everyone. That merger could be done in a way that preserves patient access, as well as some of the unique aspects of the medical program. With that eventual merger in mind, we concluded the state should probably limit the number of new medical licenses it hands out so the medical folks don't end up crowding out the new commercial applicants, including small and social equity businesses. The state would also need to decide who should regulate the commercial market. We found this authority could be vested with Virginia ABC, which could reduce operating costs and implementation risks. Alternatively, a new board and agency could be created. This approach would allow the new agency to focus solely on marijuana regulation, potentially allow for a greater emphasis on social equity or other priorities, and give the state more flexibility in who the agency reports to and whether or not it should have law enforcement powers. On the public health front, we found that while marijuana may have some therapeutic applications, legalization writ large does have some negative public health implications. Our team reviewed over 100 research studies and systematic reviews. We found that habitual marijuana use, and again I will stress habitual, can increase the risk of some negative health outcomes, especially among younger users and persons with a history of mental illness. However, those risks do generally appear to be lower than those associated with alcohol and tobacco. Obviously, a lot of people already use marijuana and so are already at risk of these health issues. However, we found that adult use is likely to go up after legalization, which could increase the prevalence of marijuana-related health problems. It's less clear what happens to youth use following legalization. In the near term, the research suggests that youth use may not go up, but that's not really clear cut. And of course, the long-term effects of legalization on youth use are uncertain. Two other big areas where the research isn't clear are traffic accidents and the use of other substances. While research shows marijuana does impair drivers, it's not clear whether legalization actually leads to more impaired driving or more traffic accidents. The research is also mixed on what effects legalization may have on the use of other substances like alcohol and opioids. Because the research isn't clear, these are two potential problem areas the state may need to address as part of legalization. Looking at other states, we found that they have taken several steps to protect public health. One step many legalized states have taken is to have statewide prevention campaigns targeting at preventing youth use. Several states have also launched campaigns to prevent impaired driving. Another thing states do is place restrictions on products and advertising to reduce the appeal of marijuana to youth. For example, several states ban edibles that resemble gummy bears or other candies, and they don't allow the use of bright colors or cartoon characters on packaging. Madam Chair, Mr. Chair, the following slide sums up our many recommendations and options for the commercial market structure and regulation. Again, I'll skip through these unless you want me to stop.
Let me ask a question. Can you hear me?
Yes, sir.
What are you going to do about people driving under the influence? Obviously, if someone is driving under the influence of alcohol, you can smell the alcohol. What is the equivalent for driving under the influence of marijuana?
It's a good question. A lot of states are grappling with it. The short answer is that what we found is that the state should just basically continue doing what it's doing to some extent, is that you still have you have on the books right now impaired driving laws that includes driving while under the influence of marijuana. So if an officer sees someone who is swerving out of lanes or riding up on the shoulder and they have a reason to believe that person is impaired, then they can go and then give them some tests to check and see. There are
Right, that's the problem, because the test, I mean, we give people a breathalyzer for alcohol. Is there any equivalent for marijuana use?
There is not a roadside test for marijuana impairment, and a bigger challenge is that unlike alcohol, there is no, even the blood test for marijuana is not necessarily a reliable indicator either of how impaired that person is. There's not the same sort of correlation that you get with alcohol and impairment. THC levels and THC tolerances vary significantly from a first-time user to a habitual user. THC in the blood drops off and metabolizes very quickly. So somebody could be impaired, but there may be no evidence of active THC in their blood. So there's a lot of problems in terms of using any sort of new approaches to try and address that. What we recommend in the report is that there are programs in place currently in the state that train officers to recognize drug impaired driving, and that includes marijuana as well as people driving under the influence of other drugs. And there's two different programs. One's a little more intense than the other. Those programs are available, and they provide officers with the tools they would need to gauge if someone is impaired driving and to get them off of the road. And talking with Commonwealth's attorneys, some would like more evidence. Some believe that is sufficient to prosecute a case. But where we came out in the report is that the bottom line here is we have laws for impaired driving. We can do some more to train officers to recognize drug impaired driving, and laws that would enact per se limits for THC similar to those that we have for blood alcohol concentration. There's no real scientific basis for those, even though some states have enacted those. I'm sorry, that was a very long answer.
No, that's, thank
Mr.
you.
Chairman?
Yes, go ahead, whoever that is.
That's Senator Eben. Thank you, Mr. Chairman. I just wanted to let the members of the subcommittees know that Senator Lucas and I have staff preparing budget amendments to increase funding to the drug recognition expert and advanced roadside impaired driving enforcement training programs for police officers. And further, just to ask Mr. Gribben, is it true that the roadside tests of people's motor skills, are those impacted if you can't pass a roadside motor skills test, that's evidence?
My understanding from talking with officers as well as some Commonwealth's attorneys is that the roadside test for impairment can be used, and the officer's judgment of impairment are the principal evidence that we presented in court. I wouldn't want to go too far on all the details of how that works, but my understanding is we do successfully prosecute people for marijuana impaired driving. It doesn't happen a lot. Part of that is because sometimes people are also alcohol impaired, so it's just easier to prosecute somebody for the alcohol impairment. But the tools are there. They're not the perfect tools. And I know that the Commonwealth's Attorneys Association, I believe, had wanted to pursue a per se limit. The issue there is that's not a perfect tool either in terms of proving that someone is impaired.
Thank you. Thank you, Mr. Chair.
Okay, proceed.
Mr. Chair?
Oh, is that Senator Marsden?
Yeah, thank you. Thank you. I had to step away for a moment. Did we discuss taxation at all?
No, sir.
Okay. We do have, of course, a medical cannabis market that we have created, and the 5 facilities, 4 of them are moving along pretty well. The one in Bristol is already providing product for sale, and for the one in Manassas. And we have not addressed the whole tax issue. Colorado, for instance, taxes medical marijuana, I think at 2 or 2.5%, but at recreational marijuana at 2 different taxes at 15%. I assume that's state and local. It's for a total of 30% tax on recreational. Did you look into any of the taxing structures for the sale of recreational marijuana?
Yes, Senator, we did. I have a discussion that coming up later in the presentation. I can fast forward to that, or I can.
No, that's okay. You just get to it when you're ready. Thank you.
Thank you, Senator. Next, I'll highlight our findings on social equity in the commercial market. Incorporating social equity into commercial marijuana markets is a concept that has recently started to gain ground. Proponents argue that communities most affected by marijuana law enforcement should have the opportunity to benefit from commercial activity. As we discussed earlier, looking at Virginia, Black residents have historically been arrested and convicted for marijuana offenses at disproportionately high rates, and so many Black communities likely qualify as being the most affected. Social equity initiatives could be targeted at these communities. This slide summarizes the main social equity initiatives that we identified. You'll see that each one has slightly different costs and benefits. I note that these are all options for consideration. The state could choose to pursue all, some, or none of these options at its discretion. One of those main options is promoting ownership of marijuana businesses. We found 3 ways the state could try and do this. First, Virginia's license structure could be designed to maximize opportunities for small social equity businesses. For example, instead of having application standards that only a large, wealthy, and experienced applicant could meet, the state could set less stringent standards that allow more people to successfully apply. Second, the state could establish a number of assistance programs to help social equity businesses to set up shop and compete. These could include everything from application assistance to providing low-interest startup loans. The third approach is to try and direct licenses towards individuals and communities who have been most affected by marijuana laws. However, there are a number of challenges here. It's not yet clear if and how it could be done, and it's not yet clear if and how it could be done successfully. The first challenge is that race probably cannot be legally used as a criteria for licensing decisions, even though Black Virginians have been disproportionately affected by marijuana laws. The second challenge is that preferential treatment programs appear to be susceptible to fraud or misuse because it is hard to set tight criteria, and there's a strong financial incentive for unscrupulous applicants to bend the rules. The few places that have tried license preference programs have encountered this latter problem. The other major way to promote social equity is to use marijuana tax revenues to fund community assistance programs. One option would be to direct funds to existing programs such as higher education grants, or a program that provides additional funding to schools with low-income students. Another option would be to establish a community reinvestment grant program like Illinois has done. Grants can be targeted at projects and communities that were most disproportionately affected by enforcement of marijuana and other drug laws. This slide summarizes the main policy options we identified for promoting social equity. Again, we have a lot more detail on this subject in the report, and I'm happy to discuss it further if anyone would like. The last item on the agenda, Madam Chair, Mr. Chairman, is revenues, costs, and timelines, and this is where we'll get into the questions that you were raising, Senator Marston. The amount of tax revenue the state could get from legalization will ultimately depend on consumer demand and how well the legal market competes against the illegal market. Marijuana use in Virginia is lower than in most states, so demand may not be as high as has been seen in some other places. The other note to keep in mind is that all existing state and local taxes should apply to the new commercial industry, including everything from state income taxes to property and B-poll taxes.
Okay, I got it.
We did not project revenues from those taxes in our analysis.
Okay, I have a question. Can you hear me?
Yes, I'm sorry, Seth. I'm
Okay.
sorry, Mr. Chairman.
Now, we've decriminalized marijuana. So if we open up our own marijuana industry and people compete with it, we can't arrest them because it's not illegal for them to possess it. What would be the tool whereby we would prevent people from competing, i.e. by selling tax-free products? I mean, how do we prevent that if we decriminalized?
The decriminalization affects possession. So up to a certain amount is possession in a person, that's just a civil penalty. There is a certain amount where or if you are possessing marijuana, but you also have scales, or there you have an extremely large amount of marijuana, then you get a charge, which is possession with intent to distribute. So in states that have legalized, you're allowed to possess up to a certain amount legally with no penalty. In most states, it's around an ounce, and in a couple states,
Right.
a little more. But there are still laws against possessing larger amounts. There are still laws against distributing without a license. Depending on the state, some of those are civil infractions. Some of them remain, I believe in most states, especially distribution, remains a criminal infraction.
So in other words, we could still be locking people up for distributing marijuana without a license.
Yes, and
Right.
what we've seen in other states is that people continue to be charged. It's mostly those more serious offenses than possession, things like distribution, illegal cultivation, and people are still charged for those. A lot of states have reduced the penalties, so they're not as harsh as they once were, but they are still often criminal penalties. So there are still laws against what you can't, that prevent people from doing those things. Arrests for things like distribution generally go down, though, because you are putting the illegal market out of business, and so you have fewer people distributing illegally. So just by that virtue, you'll see fewer of those arrests.
Okay, thanks.
So what you can see here is that we would expect marijuana sales to start off slow in the first year and grow over time as the legal market takes away market share from the illegal market, as well as demand grows a little bit over time. Based on what we've seen in other states, by year 5 of sales, the legal market should approach maturity and have captured a majority of market share. The only addendum there is some portion of that illegal market will never be captured because you will always have people who are underage who are going to try and buy marijuana, and so there will be some portion of the market that's going to serve them. The state should, of course, tax commercial sales, which all their states do. Most states apply a total effective tax of 20 to 30%. This includes both their standard sales tax and all additional special marijuana taxes. Our recommendation for Virginia is to charge a marijuana sales tax on top of the existing standard sales tax. So that would be a combined tax rate of 25 to 30%. This would put Virginia near the middle to upper end of the range with states like Illinois and Colorado. Higher taxes could make it hard to compete against the illegal market, and lower taxes would leave revenue on the table. Getting to the question earlier, we did not look at tax rates for medical. We were focused more on the commercial side, but in general, I believe what we found is that most other states, there's a lower tax rate, if any tax rate, applied to medical marijuana. With the difference there being that one is just for general use, just like any other product, whereas the other is a medical product. And so under that guise, it is not, the taxes are lower.
Mr. Chairman? This is Dave.
Senator Marston, go ahead.
Yeah, thank you. The issue here for me, the Colorado experience, I think when they were strictly a medical state and didn't have recreation, they had, my numbers could be off, but something like 235,000 people had a medical card. And when they went recreational, they dropped to 185, which is fine. But what we want to make sure is that what I think is very important is to make sure that the primary use and most beneficial use of cannabis is for those who are using it for medical purposes, for neuropathy, for intractable epilepsy, for Crohn's disease, for cancer pain, whatever. And just making sure that we keep that industry strong, so that there's a real separation between the two. Because what I would hate to see happen is people who should be using medical cannabis and have a relationship with a doctor or a pharmacist to determine which medical marijuana products are the best for their condition, is that we would overly, I'm just worried that we overly instigate people getting involved in self-diagnosis and self-treatment. In other words, going into a store and taking advice from a bud barista, behind the counter that's your medical expert. So, keeping distinctions between the medical cannabis and the recreational cannabis industries is a critical piece of making this work.
All righty. Carry
Senator,
on.
I was going to say, Senator, in our report, we do discuss the coexistence of those two, the commercial and the medical. I believe what we recommended there was that eventually you could quote unquote merge the markets by having cultivators grow for both markets, for example, or process for both markets. But when you're combining those markets, you want to preserve those key elements of the medical side as well as to ensure patient access. So, for example, the big difference would most likely be on the retail end, where you might have retailers who stay medical only retail. You will have some products that are going to be medical only products that, and then of course, as you mentioned, the tax rates would be different. The tax rates we discussed here would apply to the commercial marijuana sales, whereas the medical, I believe right now there is no special additional marijuana tax. There's only a retail sales tax. I defer to the tax folks on that one. But you would have, so the cost of the product would be lower, but you would still get the benefits of having a large supply for both the medical side as well as the adult side.
Thank you, Mr. Chairman.
Okay, carry on.
Based on the range of tax rates and projected sales, taxes could generate anywhere from 154 to 308 million in revenue 5 years after sales begin. On the left, you can see the range if Virginia went with the tax rate on the lower end of our proposed range. And the right will show you the revenues on the upper end of that range. In either case, there would be a gradual ramp up before the full amount of revenue would be collected. The state could also charge progressively higher taxes on specific products like edibles and concentrates, which is what Illinois has done. This could be slightly better for public health and, depending on the design, could generate more tax revenue. Here are our recommendations and options for taxation. The only additional note I would add here is the state may want to share new marijuana tax revenues with local governments. Establishing a commercial market will have some upfront costs before sales start. The bottom line is you would need to front around 8 to 20 million in the first 2 years to get it off the ground. Those costs could be covered from ABC revenues if you put regulatory responsibility there, or from a working capital advance that could later be repaid through marijuana license fees and tax revenues. Once everything is in place, the ongoing cost would be about 10 to 16 million per year. After the market is up and running and commercial sales start, presumably by year 3 of legalization, total revenue from licensing fees and tax revenues should easily cover all expenses. The General Assembly could direct this new revenue as it sees fit. This slide, which I borrowed from the governor's working group, shows you how other legalized states have spent their marijuana revenues. This timeline sums up all things that the state would need to do to establish a commercial market, either under new agency or under ABC. The main things to keep in mind is that you would first need to set up a regulatory function and establish the regulations for the commercial market. Only after that is in place can you start licensing operations. Then you need to wait for those licensees to pass inspections so they can start handling marijuana. Then you need to wait a few months for your cultivators to actually grow some plants. All this takes time. Additionally, assuming social equity is a goal, you will need time to establish your social equity programs and to have them bear fruit. And again, I would point out this is the timeline for the commercial market. The changes to criminal laws, which I discussed earlier, would not have to wait on this. Madam Chair, Mr. Chairman, that concludes my presentation. I'm happy to answer any further questions that you or the members of the committee may have. Of course, I'll be available day or night in the coming weeks if needed.
Thank you.
Mr. Chair,
Senator Evan.
if members of the subcommittee would like to get a copy of the JLARC report in hard copy, is that in the bill room or do we get that from you?
Senator, I can.
Go ahead. Please go ahead.
I'm sorry, Mr. Chairman. I didn't mean to interrupt. Senator, I can make sure we get a copy to you either at your office in Richmond or we could have one mailed to you wherever.
Okay. Thank you. And also, one thing you mentioned about the opioids surprised me. I'd read that in states where they had legal marijuana, that opioid use was estimated to be lower than in states where they had did not have marijuana. Is that, did I miss something? I thought that was in the news in the last 6 months or so.
There's a lot of research on there. That's certainly true. But we've also, so a lot of these studies that came out early on were suggesting that there might be a trade-off there. Some more recent studies have put some of that into question. They pointed in a different direction. For example, there was a study looking at what happened to people who had opioid prescriptions who then started using medical marijuana, and there was really no difference in their use of opioid prescriptions. So the research is still emerging in that area. It could be that if somebody has already started taking the opioids, that then the medical marijuana doesn't get them off of opioids. It's possible that if somebody starts on medical marijuana, then they don't go to opioids, but the research there, it's a little mixed. So the message, we weren't confident that you could say one way or the other how that would play out.
Okay, thank you.
Okay. Any more questions from the panel, Louise?
No,
All
I
right,
don't think there are any questions. You can go on and proceed with introduction of Kristen White.
Yep. Go ahead. So Virginia State Police, do we have a rep here?
Yes, sir, Mr. Chair. This is Colonel Suttle.
Colonel.
Good afternoon.
Welcome aboard.
Good afternoon, and Madam Chair Lucas and Chair Peterson, thank you for the opportunity to present this afternoon.
Thank you for being here.
I will present on 4 specific topics today, the last one being the expungement process, which will be done by Major Hook, and I will touch base on the first 3. The next slide, please. Thank you. The first topic being VETA transformation, and you will see under item 425, which is included in the appropriation budget for $1,147,694 for the first year, and $5,209,045 for the second year from the general fund to implement the phase 1 transformation. It'll be a 2-phase transformation. Of course, phase 1 is, and phase 2 is to address the department's information technology concerns and in compliance with the Code of Virginia. The first phase, if I can go to the next slide, slide 3, please. It's to begin in March of 2021, estimated to take approximately 2 years. This will include our core network, our division and our area offices across the state, their network specifically, an Active Directory. Of course, the PC piece of this, the end user migration, if you will. The projected cost is about $434,000 a month for 24 months, a total of 10.4. Phase 2 will begin in 2023, estimated to take approximately 2 years as well. This will include VSP's server and storage infrastructure migration to the Commonwealth's enterprise cloud environment. Projected cost of about $1.4 million per month for 24 months. This total cost of 33.4 is high level projections and excludes any disaster recovery that might occur. Next slide, please. The next item to talk about is our increased cost associated with our patrol vehicles. It's kind of an unanticipated cost increase because the current vehicle that we have has been discontinued. And the vehicle now that we will be pursuing and have actually started purchasing is the SUV. Of course, it's about a 51% increase with costs with this new replacement. And department is developing a detailed fleet replacement schedule that will be presented by October of every year. It'll have the details with regards to mileage and other opportunities and assessments that might have a savings, if you will. Next slide, please. As I mentioned, the Ford was discontinued, and it's, again, an unavoidable cost. You'll see a picture in the right-hand bottom. That is the patrol vehicle that we're currently going to now. That's the SUV. The one challenge we have is when you change manufacturers, the equipment that's in the old vehicle or the one that's being replaced is not transferable over to another vehicle that is by another manufacturer. So that increases the cost of about $7,400 of extra equipment or repurchasing equipment to fit that particular vehicle. Next slide, please. The next slide here you will see, and I believe, can we back up one side, Caitlin, please? Back up to slide 4, maybe. Yeah, okay. I'm sorry. I thought I had missed a slide here. I apologize. Slide 6, please. Thank you. This is the proposed administration budget amendment that was spoke of earlier by the senator with regards to DREs, or drug recognition experts. And this is for VSPs and VSP and localities in support of the governor's adult use cannabis legislation bill. This is a funding appropriation of about $1.2 million to train and certify law enforcement officers in drug recognition training. And this will provide us an effective detection and enforcement for driving under the influence. It will allow us to assess the motor skills of drivers and assess and evaluate whether or not the driver is under the influence of marijuana and or other drugs. Next slide, please. I'll turn this over now to Major Keenan to talk about the expungement process, unless there are any questions on what I just presented on. Thank you, Madam Chair.
Thank you so much, Colonel Settle.
Thank you, Colonel Settle and Chairman Lucas and Chairman Peterson. I'm going to talk to you today about our expungement process and opportunities for improvements and challenges there with regards to some of the expungement legislation that has historically been proposed in this area. Although I'm not speaking today to any specific bill or any specific proposal, just trying to give you an overall point of view on the process. So let's see, can I have the next slide, please? All right. In fact, skip one ahead if you don't mind. There we go. So expungement really gets talked about as a broad term that can mean a few different things. And as you can see from the 3 columns here, the left-hand column, expungement, that's a traditional expungement process. That's what we do now in Virginia. And I'm going to talk in a little bit more detail on some subsequent slides about what that looks like. And then all the way off on the right-hand side, you have record sealing. We're doing that right now for marijuana offenses. And what that is simply limiting essentially at the firewall, which entities can and cannot have access to certain types of records. So as with marijuana, the General Assembly established the criteria for who could and couldn't have access to the record and what records we were talking about. And then we programmed that in at our switch to filter out those entities and not allow anybody who wasn't authorized to see that record access to that particular record, although they would get a criminal history record back in response to an inquiry that looks complete, and it is complete for their purposes. They're not entitled to the additional information. So that's sealing. Record expiration, and we've been back and forth about a term to describe this. It gets talked about in many ways, but what it goes to is the idea that given specific parameters, we would simply drop a charge off the record when those criteria are met. So you may hear the courts refer to it as a petitionless expungement process. I think that's a good way of thinking of it if it's designed one way, as in it looks mostly like a traditional expungement, but it doesn't require a petition because things are driven by pre-established criteria. That's one way to do it. Another way to do it looks a lot more like sealing in that those criteria are established, and it's not really sealing in that the record has much more limited availability, but neither is it full expungement. So it really does it have the potential to span in both directions. As the left-hand column indicates, expungement is a very labor-intensive manual process, and really to do much in terms of high-volume expungement requires new systems. Record expiration and sealing, on the other hand, can be implemented electronically and avoid some of the manual labor costs, but critically here, that depends, at least with our current system architecture, depends on the having fairly low barriers on the conditions and complexity associated with criteria around the sealing of records. And if I could have the next slide, please. So our current process, in terms of the manual challenges there, labor-intensive challenges, as you can see, we can do 500 expungements per employee per year, and we routinely exceed the capacity of our core staff to do that now. So we've trained additional personnel to step in and meet some of the volume demands. Of course, you know, what we're talking about there is we may exceed volume by 1,000 or 1,500 in a year. Obviously, some of these expungement bills have literally hundreds of thousands of potential charges to expunge. So it gets out of the scope of what we can do manually very quickly. And if I could have the next slide. So this outlines the process, the current expungement process, and every one of these boxes, I won't go through them in great detail, but every one of the boxes is a manual step in the process from the time that the Virginia State Police receives a set of fingerprints related to an expungement in the mail, and then we have to match it up to a petition. Often the petition, although by statute the petition should come with it, often it doesn't, which requires outreach to the court to obtain a copy of that. And then we review, we run the prints, we obtain the criminal history and send that back to the court, again, manually. Once the court orders the expungement, they send that back over to us. We review that for legal sufficiency. If there are issues with that, we send that over to the Attorney General's office, who may try to intervene or pursue getting the expungement order vacated. Then once we're through that step, we go back and do a two-year audit to determine anybody who's run the record that may have that expunged information on it. And then we send each of those entities a notification that they have to expunge their records, sometimes prompting them 2 and 3 times before we get confirmation that all records have been expunged. And then we let the petitioner know that the record has been fully expunged. And I didn't speak to in there our own internal process. Of course, one of the first things we do when that order comes in is go ahead and expunge our own records by removing them from the repository and placing them in a separate sealed file. So that's an outline of the current process that we can do 500 per employee per year. Next slide, please. All right, so alternatives to that involve automating many of these processes, essentially taking what is now manual and through system upgrades or replacing systems, making those electronic steps in the process. Next slide. All right, so this is what an electronic process would look like. And now every one of these boxes essentially happens electronically. So most of the steps I just described to you are in there, with the exception of at the end, we would no longer verify that an expungement was completed by an end user agency. We would establish a process by which we could verify that they obtained the notification, and then like any other court order, it's going to be up to them to comply. There are manual processes involved. We still have to verify the prints. We still have to verify that the record does belong to the correct subject. So there are, it doesn't get us out of the realm of manual work, but it dramatically improves it. Next slide. All right, so we think, you see here, 2,000 expungements per year. We think at least a 4-fold improvement in efficiency, which would be critical to doing high volume expungement work. Obviously, it's much more efficient, faster, and more effective for the types of expungements that we've seen proposed. Next slide. All right, so the other alternative solutions, now what I just described to you would be fully automating the existing manual expungement process. In other words, everything that happens today would essentially still happen, to include the state police system having the responsibility of notifying the downstream entities that obtain the record of their obligation to expunge records. The alternatives with expiration of record or electronic sealing of records don't obviously reach as far. They don't go to a hard copy record sitting in a file in a police agency or elsewhere, but they do get at anywhere that is that's within the state-controlled repositories of that data. So whether we're talking about sealing or expiration of records, again, the key here is complexity. So what we've seen, for example, when we sealed marijuana offenses, it took us several months and a little over $100,000 worth of programming work to get it done. We got it done fine. We met the deadline. However, it is important to consider that that was one offense. So it was limited in its expanse. And it was also limited in its complexity in that there were, I think, roughly 12 or 13 different individual use cases where someone would have access to the marijuana charge that still exists in the repository. For example, for a criminal justice purpose or for employment at the Department of Forensic Science. Those were specified cases that would have access to the record. So we could extend that into other charge areas. We could broaden it beyond 250.1. The trick is if we also start to change the entities that have access to the record, every time we make a change, well, this charge is relevant to this entity, but not to this one. It adds to complexity. And similarly with record expiration, often we've seen proposals that records will expire after a period of years, after fines and costs have been paid, varying conditions being met. Those also become challenges for us when those criteria are not fairly standard, uniform. For example, it's relatively easy for us to, on a standard set of criteria, if every charge being automatically expired or expunged had, for example, 5 years with no subsequent record, if we say no subsequent Virginia record, we can ascertain that pretty easily through our database. If we say no subsequent record out of state, that automatically becomes a manual process. There's no way to program any system to read other states' records because all 50 states' records look different. So those present challenges. So the bottom line there is, when presented with a fairly simple solution, and especially where presented with only one new change, our current system, we can absorb that with a fairly minimal cost. And minimal is the wrong word. It depends on what it is. I think our expiration of records costs tend to be in the around $1 million for something simple versus sealing, which was $100,000 for marijuana. But the key is this: our criminal history system is, while we replaced it, we modernized it in 2016. What we really did there was bring it from its legacy platform onto a Java architecture, but we kept all of the same system logic that existed from 30 years prior. So that system really is not robust in terms of its ability to make changes and adapt to new requirements and provisions. In fact, things as simple as running reports to retrieve data, if we don't parse some of the larger data requests out into smaller and smaller subsets, we're at risk of crashing the system. So it's not robust. It's very difficult to program changes into. And so next slide, please. And so our takeaway from that is that really, in order to adapt to a changing expungement environment, what we need is to replace those systems. Again, simple sealing, not an issue. A very simple record expiration, not an issue. But anything that has more than a variable or two, or is expunging across a gamut of charges with different considerations, we can't do it without new systems. We've estimated the cost of replacing the key systems that would be needed to do this, which are criminal history and what's called our consolidated applicant tracking system, but that's basically the background check system, civil commitments, and master name index, which is the system behind the system that performs name searches. Replacing all those is a $12.5 million cost. It also has, we think, about a $1.9 million annual maintenance fee going forward. That's still much cheaper than the individual replacement of those systems, which is on the horizon anyway. And it also allows us to implement wrap-back at the same time, which will solve problems for other state agencies such as social services, which right now has to request annual waivers from a federal requirement related to background checks of individuals who provide care for children, because our current technology will not allow them to receive updates when somebody has a new prohibitor. They've got to rerun that record periodically instead, which is, of course, a stale snapshot in time. So that's the overall picture. I think I got one more slide. Yep. So that's what I've got. I'll answer any questions you have.
Keenan, this is Chap Peterson. I noticed that there was $25 million allocated in the governor's budget amendments for expungement, which to me sounds like a lot of money. Because I think of expungements as being a relatively low cost legal petition. Can you tell me kind of what's the bang per dollar here? I mean, how much are we paying for each expungement? How many convictions do we need to expunge? I guess that may be variable depending on what legislation we pass. But what are we talking about? Because I mean, it seems to me if it's over, say, $500 per expunge, it just sounds very expensive for, I don't know how many petitions. So what are the apples to apples comparison for a dollar figure for expunging violations?
Well, Senator Peterson, the cost, I don't know where the $25 million number came from. I suspect that incorporates costs to make changes, not just to the state police process, but also to the court's end of the expungement process. And what is driving those costs at the end of the day, I think, is simply the volume of expungements that we're potentially dealing with. So if you just take marijuana alone, simple possession of marijuana and misdemeanor possession with intent to distribute or distribution of marijuana, there are about 350,000 of those offenses in the database. So the traditional expungement process, when one person can do 500 of those in a year, because while it may not be an expensive process for the petitioner, it is a time-consuming process for us for the reasons we analyzed that I outlined earlier. So with one person doing 500 a year, obviously, if we were going to expunge 350,000 charges at the front end, we wouldn't try to do that with employees, because once we got through the first 350,000, we wouldn't have enough work for them to do. But we would have to have a force of contractors able to chew through that if we did not automate. The contractors are more expensive than automation. So ultimately, that high volume work requires automation for true expungements. If it's less than a full expungement of every copy of a record that went downstream, then as a automatic process, there are ways of reducing those costs, but certainly not eliminating.
Senator Peterson, may I ask a question?
Yes, go ahead. I got cut off there for a second, but Adam, go ahead.
I'm sorry. I was going to ask, the term expungement, do you expunge a conviction or do you expunge a charge as well?
Senator Evan, currently we expunge, I understand your question now. So right now we are only expunging non-convictions. We're only expunging dismissals and acquittals in Virginia, but looking forward, the bill's proposing to expunge convictions. We expunge everything associated with that. So the initial arrest, also the expungement would be, the conviction would be expunged under those bills. So there'd be no evidence of the charge in any way.
Thank you, Mr. Chairman. Thank you, sir.
Okay. Any other questions from the panel? And then I wanted to follow up on mine. Any other questions for Keenan on expungements? Okay, Keenan, I just want to say I got cut off there for a second. What would be helpful to me is if you could just give us, or give me or whomever's interested, kind of a dollar per figure, how much it costs the government to process one of these expungements, whether it's $15 per expungement, $25, whether it makes a difference if it's a misdemeanor or felony, whether it makes a difference if it's a charge versus a conviction, but just so we know kind of what we're getting, as opposed to just this big block figure of 25 million, and you just don't know what that represents. Because again, I think of an expungement as being a fairly simple procedure, but obviously it's more expensive or more complicated on your end.
Yes, sir, Senator Peterson. I think the best thing for me to do there is to go back and crunch those numbers and get back to you on that. Again, I don't think the per expungement cost is that much. I think what's happening here is you're talking about a 100-fold increase in the number of expungements. So that's what drives it. But I will follow up with you and get you a per expungement cost analysis.
That's helpful. Okay. Madam Chairman, that's all I've got. It looks like from my panel. I don't know if y'all have any other questions for your panel.
Yes, I think you had a third speaker.
Okay. If so, if that person wants to step
Christy
forward.
Wright with the Supreme Court there.
Oh, okay.
Yes, ma'am, I'm here. Can you hear me?
Yes, we can
Yeah.
hear you.
All right, thank you.
This is Christy Wright with the Supreme Court.
Yes, ma'am. Thank you, Madam Chairman. If you can go to slide 2, I was asked to present on 2 things. One was the data vault that the General Assembly provided funding for in 2020, and then also an overview of expungement in the courts. The first topic is the data vault, and this actually goes a little bit to Senator Evans' question, I think, but the purpose of expungements is for the expunged case to no longer exist. And so the idea is that there would be no evidence that a case ever existed. Both the case that is the subject of the order and the case in which the person asked for the expungement, so that petition for expungement, are destroyed when the court orders an expungement. And this ensures that there's no case record of either that would exist for someone to be able to access. Currently, the number of expungement cases is relatively low, and the effect on our case counts and statistics is minimal. With the anticipated expansion of expungements, we recognize that counting both cases, both the underlying case as well as the petition for expungement, is important for court statistical and planning purposes, including the weighted caseload studies that we do for judges and clerks. And the loss of this information, if those records are expunged and no longer exist, would have a significant detrimental impact on the courts. Next slide, please. So in order to preserve that basic de-identified case information for the courts to use for planning and statistical purposes, there was about $300,000 provided for us to create a data vault that was related to Senate Bill 640 in the 2020 General Assembly. That bill created a process to expunge unlawful detainer cases. And as the number of expungement bills increased last year, and we saw many of them, that's when we said we really need to be able to protect this information to have it for statistical purposes. And that was provided for that particular bill. Again, as I said, that de-identified case information will be used for judicial and clerk workload studies. It's also used by our office to help courts and clerks understand and improve efficiency and case processing. So for example, courts are interested in how long does it take from the filing of a case to the disposition. Just trying to help improve the court's efficiency. And so that is also very valuable. So Senate Bill 640 had a delayed effective date of January 1 of 2020. And we are currently on course and on budget to have that data vault operational by January 1 of 2022. And that same data vault that would be used for the unlawful detainer or the eviction expungements, we would also utilize that to maintain that de-identified statistical information for our planning purposes. Madam Chair, that's all I have for that particular topic, and I'd be happy to go on to expungements or answer questions now on this.
Senator Peterson? Okay, are there any questions at this point? Otherwise,
I don't have anything.
Madam Chair, it's Senator Eben.
yes, Senator Evans.
Just to ask Ms. Wright, the data vault that she said would be effective January 1st, 2022. If expungements for marijuana or any other offense were to start taking effect July 1st of 2021, would we need to do anything differently in terms of appropriations for you all?
I think the difficulty is less about the money to do it and rather the timing of it in order to have it ready by that time, as far as us, being able to place staff on it to be able to accomplish it in that time frame. It's something that I would have to check on and see.
So just to follow up, Madam Chair, then it sounds like if we were doing expungements for marijuana or for other things, that the effective date of legislation this year for that piece should be January 1st, 2022, absent some way to accelerate your work.
Yes, I think that would be the case. I think that would be helpful. And the existing expungements right now for the marijuana was strictly related to criminal history, which is the Virginia State Police.
I see. Thank
Right.
you.
Mm-hmm.
If there are no further questions at that point, I would like for Christy Wright to continue with the presentation.
Thank you. If I can have the next slide, please. And so I think many of the points that the Virginia State Police made related to expungement apply to us, and you're going to hear some of them again in my comments. And there's, terminology matters in this, and there's really a few different things that we're looking at. And I think, all being able to everybody coalesce around one of these specific terms, I think is helpful. So we all know we're talking about the same thing. But for expungements, there's also sealing, and expungements restrict access to the court's case file, and it removes that case information from the electronic case management systems, which is the information that you see online. Compare that to sealing, which it restricts access to the court's case file and electronic case information, although that electronic case information remains in the system. And there are safeguards put into place to restrict that access and to protect it. Under expungement, clerks must engage in a multi-step manual process. And I think, as state police acknowledged too, for them, it's time intensive for their staff, and expungement is as well for our staff. Sealing can be accomplished through a combination of clerk time, and it is a reduced amount of clerk time, and IT changes. So there are ways that the cases can stay on the shelf, so to speak, or in the file. It can remain in case management, but there are protections put in place so that that information is not further shared. Under expungement, access to expunged records is by the court order only. I believe that where the direction for sealing is going is that the information within the case file may be accessed as specified in the code. I think the intent is that certain groups or individuals could continue to have access to it as specified in the code. And then finally, under expungement, records are destroyed based on the retention period established in the code, but pursuant to statutory provisions, those must be maintained for 3 years after the expungement order. And that is to ensure that it's voidable within 3 years. So if the parties didn't strictly comply with the procedures, or the order was rendered contrary to law, those records would exist and I think could be reinstated. For sealing, the records are destroyed based on the retention period established in the code. So, for example, for general district court records, most misdemeanors are maintained for 10 years. And so once that period would be hit, then the records would be destroyed under their regular records retention period. Next slide, please. I forget how state police referred to this, but the term often used is automatic expungement or sealing. There's a lot of discussion about automatic, and I would say that a more accurate term for automatic is petitionless expungement or sealing. Automatic expungement or sealing is accomplished through electronic communications and does not involve the filing of a petition or a court hearing, although I will tell you that it is not without clerk time and clerk effort, but the emphasis is on the IT. The cases to be sealed or expunged are based upon information with existing case management systems. So, for example, this means that if a condition of the case is that they want it based on a passage of time, say from a release of incarceration, that information is not something that is maintained in case management. The length of sentence, the order, what the person was ordered to serve is in our case management. But if they were released from jail early or on whatever circumstances, we may not know that. And so the court does not maintain that. The jail or DOC may know that. But if a search of our electronic records to trigger that sealing or that expungement, we would not have that. However, if that 10 years is from the date of the final disposition, that is in our case management, and that could then trigger that sealing or the expungement. Again, as I said, the expected result is not without clerk effort, but it is reduced. But really the emphasis on automatic expungement or sealing is on the technology changes. And I think, again, that's what state police looked at and spoke a great deal about. House Bill 5146 from the 2020 special session took this approach, and we had estimated a one-time cost of approximately $6 million to complete those necessary IT changes. And I believe someone asked about the 25 million that was in the budget. I believe a portion of that, the 6 million, was related to the fiscal impact that we put on this House bill in the special session. But again, that is related to the IT for what is being termed automatic expungement or sealing. If I can have the next slide, please. So right now, we don't have anything such as that automatic expungement or sealing, and what we have is expungement. And so what I've laid out here is the 10-step process. This is in the general district court records, what a clerk undertakes in order to to expunge that record. And as you can see, I won't go through each of them, but there's a lot of steps that need to be taken to make sure that it is secured. And when you're talking about this sort of expungement, you are talking about primarily clerk time. If you have the petition that is filed in the circuit court, you will have judge time. You will have circuit court clerk time, and they are independent and not under us as far as budget items, and so they would have to provide what impact that would have if this is expanded for their staff. But there's circuit court clerk time, and then if you're trying to expunge a record in the general district court, that petition is typically made in the circuit court, with the order then going to state police. And then state police notifies the district court that it is to expunge their records. And that is what you have before you, is once the general district court receives that notification, there are those 10 steps to effectuate that expungement. Next slide, please. Okay, so this page is intended to really just summarize it. And so you have expungement or sealing by petition. And that requires significant time of judges and clerks to process, to hear that petition. And you will expect to see increased caseloads and a need for additional judges and clerks with this approach. Of course, the impact is going to depend on the breadth of cases that are eligible for expungement or that sealing. Then once a clerk's office is advised that the case should be expunged, that the steps for expungement require significant clerk time. We estimate and we used 10 minutes of district court clerk time for each case expunged. And as I said again, the breadth of types of cases that can be expunged will directly impact our estimated fiscal impact and would likely result in the need for additional district court clerks. I will add that, so if you look at 10 minutes does not sound like a lot of time. Except when you consider the volume. So if you do 10 minutes a case, that's only 6 cases in 1 hour. And in a day's work, that's 48 cases that the clerk would be able to expunge in a day. And I will tell you that clerks and deputy clerks are trying to do so much more than that. And so this will have an impact. And especially when you look at the processing of new cases that need to come in so they can get on the docket to be heard. And that additional clerk, a district court clerk, is in addition to the 156 positions that are currently needed. We very much appreciate and are thankful for the 120 positions that were provided in the 2020 special session. but it's important, I don't want to lose sight that that was only a portion of the total needed and that 156 still remain. And then although sealing requires clerk time, it does require less time than expungement because there's less of the pulling it from the off the shelf, putting it in an envelope, dating it, sealing, truly like sealing it. And so we estimate for sealing 6 minutes of district court clerk time. For automatic expungement or sealing, that is what has the least impact on judges and clerks, especially if you're identifying them electronically. It is not a petition process, so you don't have judge time. But to replace that, you do have changes to the IT systems, and that is where you would encounter cost. Thank you. That's all I have, and I'm happy to answer any questions.
Thank you very much. Does any member have any questions of Christy Wright from the from the Supreme Court?
No, ma'am.
Senator Barker, did you have a question?
No.
I just see that you're unmuted.
Okay.
Well, if there are no further questions, Senator Peterson?
Senator Lucas, I think we're at a conclusion.
Okay, then I would like to then thank each member of the Public Safety Subcommittee. First of all, for your presence here today and also for your questions and participation in the discussion. And I'd also like to thank each of our 3 presenters for providing us with this helpful information as we prepare for a productive legislative session. Senator Peterson, would you like to have any closing remarks before we adjourn?
Thank you, Senator Lucas. Just want to thank you for allowing us to participate. Thank the presenters. I think these are obviously a somewhat select number of issues that we will tackle. There's some other big issues, thorough briefing on this today. So thank you.
Thank you, Senator Peterson. Well, no further comments. The
I
meeting
move
is
we adjourn.
The meeting is now adjourned. Thank you so much.